All right, welcome to the SnyderReport podcast. I am your host, Gary Snyder. Before we get to our first guest, let me thank our sponsors tonight. First of all, Robin Winston. He has been instrumental in getting this podcast launched and also part of the newsletter that helps us get it out each morning to about 100,000 people. And also former Congresswoman Jill Long Thompson. Again, thank you for the sponsorships, makes all this possible. My guest tonight is author Rachel Barkow. Rachel, welcome to the SnyderReport.
Thanks for having me.
Before you're an author, you just wrote a book, How the Supreme Court Ignored the Constitution and Enabled Mass Incarceration. Before we get to that, why don't you just take a few minutes and tell our listeners a little bit about yourself?
Sure. So I'm a law professor at NYU School of Law, and I've been here for about 22 years. And I specialize in criminal law and constitutional law. And before I came into academia, I was a practicing lawyer, and I was also a law clerk at the Supreme Court for Justice Scalia. So my background in being interested in Supreme Court issues goes back a long time.
So do you, writing a book like this, and obviously I saw you on MSNBC and I thought I'd love to have you as a guest, but do you catch any flack for clerking for Justice Scalia?
Yeah, so yes, I have. I'm personally a Democrat. I was when I clerked. I have been the whole time. He sometimes hired law clerks who didn't share his political views, which I respected that he was willing to do that. And
Mhm.
I thought it was a great experience because I really learned a lot about different perspectives on legal issues and political issues. But yeah, I've definitely received my share of how could you do that? Didn't you fight all the time? And we really didn't. And I think one of the things about this book, for example, is pointing out that you could be someone like him who was a textualist and originalist, and actually some of the outcomes, if you're faithful to the methodology, actually would produce liberal results. And and my term, there really weren't a lot of the really controversial cases.
Mhm.
I think the court is a little different today than it was back when I clerked, which was a while ago now. But so I'm not saying it's always possible for somebody to clerk for a justice who has a different political ideology, but it worked okay for me.
In such a divided political environment, was writing a book at this point in time a little concerning at all due to any backlash you might receive from people that don't
Yeah,
agree with it?
yeah. I feel like one of the things about this book that I hope to do is find common ground actually among people from across the political spectrum, because the arguments I'm making are really about core constitutional values that are grounded in the Constitution's text, its original meaning. So, the people, lots of conservative justices always talk about being guided by the original meaning. And all the cases I'm talking about, um, my argument is that it's not being true to the original meaning to
Mhm.
have those cases decided that way, in a way that did lead to mass incarceration. So the hope is that it can kind of bridge some political divides because it rests on a neutral methodological approach, and it produces this particular outcome. And, I've argued in the past in my previous book and another writing, it won't make us less safe either. So, to the extent we have a lot of political divisions about criminal justice policies that are about, is it going to make us safe? Is it dangerous? It's not the case that if you followed the Constitution's meaning in these cases, that we would somehow be in a worse situation for higher crime rates or things like that. So I'm hoping that it shouldn't be controversial, but these days it seems like everything is.
Everything
So,
is.
I don't want to claim that it's not going to be a possibility.
Well, the name of the book is Justice Abandoned, How the Supreme Court Ignored the Constitution and Enabled Mass Incarceration. Tell us why the book, why now?
Yeah, so a lot of people I think have been very interested in how the United States became the most punitive country on earth. We have more prisoners than any other country. We really use long sentences, criminalization more than anybody else. And a lot of people, including myself, have explored what are the political forces that led to that, historical and cultural. And one thing that's been missing from the conversation is the Supreme Court's role, because you really can't get this many people locked up for this long without a Supreme Court that ignores key constitutional checks. So I really wanted to make sure that people understood that part of the reason we look the way we do in terms of our mass incarceration is that the Supreme Court failed to adhere to constitutional protections. And I outline it through a series of 6 cases in the book, and I explain, the original constitutional understanding, how the Supreme Court got it wrong, and then what happens afterwards. And so I was hoping to, basically get people to pay attention to the Supreme Court's role, and then also possibly use that as a way to help solve it, because if it turns out that these cases are wrongly decided, we have a Supreme Court that's very willing to overrule cases right now, no matter how long they've been around. We
Right.
saw
And we
that with
see that. I mean,
Roe
we see
versus
that
Wade
almost
and
on a
Dobbs.
daily basis.
Yeah. And so the hope is that, okay, fine, court, if you're willing to do that, um, why don't we put the court to the test in some cases like these where, the outcome actually is not a conservative one, but it really should follow the court's methodology for them to overrule or at least limit these kinds of cases precisely because they contradict the original meaning. So my hope is both to educate the public, but also really to start getting litigants and people who are interested in criminal justice reform to actually start to bring some challenges.
You talk about 6 cases. Why don't you just maybe walk us through a couple of those? What maybe you think is the most important one?
Okay, well, so I'll give you an example. Is there's a case, United States versus Salerno. It was decided in 1987, and it's a case that asks whether or not it's constitutional for somebody to be detained before they've been convicted of a crime. So, they're arrested. Can they be detained just because the government makes an allegation that they're dangerous? So, for almost the entirety of our country's history, the answer to that was no. You could detain people after they'd been arrested, but only because they were a risk of flight. So the worry was just, that's why we have bail, is basically we want to just guarantee that someone comes back to court and has their trial. And if you thought somebody was a danger, you had to go through civil commitment proceedings. You'd have to show by clear and convincing evidence that they were dangerous. And that was the understanding for most of our country's history until the end of the 1960s. And at that point, crime is rising, and you get President Nixon decides that he wants to try to, he ran on a law and order platform. He wants to make the claim that he's doing something about crime. So he has one of the lawyers in his administration, a young Bill Rehnquist, who will become the Chief Justice later. But Bill Rehnquist helps draft a law in the District of Columbia that would allow, after someone has been arrested, it would allow prosecutors to have them incarcerated pending their trial if the government could show that there was a substantial probability they committed the crime and that they present a danger, and they could be held up to 60 days. It's like the first time this issue is going to come before the courts, because as I said before that, nobody thought that was okay. And the Nixon administration, the Attorney General, John Mitchell, who himself will go to prison later as part of Watergate, he writes an article trying to defend this practice. It's, because they know they're doing something really novel and different. A lower court upholds it, and after they do, lots of states and the federal government decide we should do the same thing. We should have way more pretrial detention. And so there's a federal law that allows this to happen. But the federal law, unlike the DC law, will allow people to be detained with no time limit. So they could, not 60 days now, it could be any amount of time. And there's no requirement that you show a substantial probability the person committed the crime. In fact, they create all kinds of presumptions of dangerousness. That case is the one that goes before the Supreme Court. And the government decides to bring the case. The case they bring to challenge it is against Anthony Salerno, and he's the head of the Genovese crime family. So his nickname is Fat Tony. So Fat Tony Salerno and one of his lieutenants are the two people that the court brings the case against. So his lieutenant is Vincent Calfano, who's known as Fish, and the government says, look how dangerous, they're mob bosses. How could you not detain them pre-trial? What the government doesn't tell the court is that, first of all, Fat Tony had already been convicted and was starting to serve a 100-year sentence. So he wasn't even in pretrial detention anymore. And his lieutenant, Cafano, was also out because he had signed up as a cooperator with the government. So the case comes up on really kind of iffy circumstances. But the Supreme Court decides 6-3 in an opinion written by Bill Rehnquist that this is okay. And so it's the first time the Supreme Court says it's okay. And after the court decides the case, lots of states around the country decide they're going to pass laws like that too. And the number of people held who are presumed innocent, right? They have not been convicted of anything. The number of people just skyrockets. So between 1970 and 2015, you have a 433% increase in the number of people who are detained pretrial. And without the time limit, the average in federal court is almost a year. So they're in cells for almost a year, not having been found guilty of anything, with very little determination that they are in fact even dangerous. There's like all kinds of presumptions in drug cases. So we have now in America almost 500,000 people on any given day who are presumed innocent, but they're locked behind bars. And, that would have been unheard of to the framers of our country. And the only reason it happens is because we had a president who decided he wanted to try to push the envelope, make the argument it was necessary for public safety, and then a Supreme Court that capitulates to that claim. I think there's lots of echoes today to things that we see in the news when it comes to immigration and immigration detention and aggressiveness. It's very similar in terms of scare tactics. I think the court gets scared is the lesson that you see in this book repeatedly. And I think they went along with the government's claim. And as a result of that, that's a big part of our mass incarceration pie is this pretrial population. And I think that case is a good example of some of the others that I talk about in the book, just kind of how it happens, how it doesn't have a basis in law as we traditionally think of it. But ultimately, the court gives in because the government gets the court, sufficiently scared like the rest of the country, basically, and they go along.
When you take a look at the makeup of today's Supreme Court, they have shown no hesitation in overturning case law from Roe versus Wade 50 years ago. Do you see today's Supreme Court applying the cases that you highlight? Do you see today's Supreme Court maybe putting any of those rulings in jeopardy?
Yeah, I mean, it's hard to say, what when the court has overruled the cases it has, it has produced conservative results. So, when we look at the kinds of cases where longstanding precedent has fallen, it's also produced an outcome that conservatives like, Republicans like. And what's different about the cases that I'm writing about is overturning these would produce outcomes that are more progressive in orientation. I like to think of them as just pro-liberty. So I feel like they
Right.
shouldn't have a party affiliation. But, let's be honest, in America today, it really would be thought of as a more liberal outcome. So, whether the court would be willing to overrule a longstanding precedent when that happens, is a tougher call. But some of the justices have done it. They rethought the requirement that juries be unanimous, insisting that they must be. That had the court overrule a precedent that was favorable to criminal defendants, and they did it. There was a majority to do that. So there's some signs of possibility out there. Justice Gorsuch has been pretty good. In criminal cases, if the original meaning says you have to do something, he's pretty quick to be willing to overrule cases. And he's been willing to do it, though, even when, this outcome would benefit a criminal defendant. So, there's ways you could get to 5 and get 5 votes to do this. So I think it's possible. If it turns out that it doesn't happen, though, if you get cases before the court and they ultimately don't do it, at least at a minimum, then it would, I think, show some hypocrisy. And there might be some value to that, so even if there's there's not a win here on the outcome, at least it would expose then that what the court is doing is not faithful originalism, but is instead, just finding ways to get to outcomes that they like.
When we look at the mass incarceration today, you mentioned pretrial holding. Did you take a look at what the war on drugs or what the war on whatever your issue of the day is plays on this? Because the war on drugs puts a lot of people disproportionately of color in prison that we can go back and look at crack versus cocaine as an example. Did you find any examples of that?
Yeah, so I guess a couple things about the war on drugs. So you're
Hmm.
certainly right that it's a big part of, driving lots more people to be serving prison sentences. It leads to a lot of aggressive policing tactics. You know, if we released every person who's incarcerated for a drug offense, which obviously is not in the offing, but if we did, we'd still be the most carceral country on the planet. So I always
Seriously.
try to make sure I tell people it's not just drugs. It's actually more complicated. I mean, drugs are a part of it for sure. It's about a quarter of the whole prison population. Uh, but that means that 75%, is there for other things. And
Hmm.
a lot of those crimes do involve violence. So, it's tricky if you want to end mass incarceration. It is important to confront that, some of these crimes, a lot of these crimes involve violence. And so you do need to think about, okay, well, how are you going to handle that? And mainly, I think uh, one of the issues is how long does somebody need to serve time in prison in order for them to be a changed person, to have outgrown some youthful, you know,
Hmm.
basically impulses to commit crime. Crime is usually a young person's activity, to be honest with you. And there's all kinds of studies that show this, that basically people age out of most violent crimes. But in America, starting in the 1970s, we really started to sentence people for way long sentences, well past the point at which they needed to continue to be incarcerated if what we were worried about was reoffending. So, but I do think that you're right to bring up drugs. I mean, one of the cases I do talk about in the book is a case involving uh, how whether a sentence is unconstitutionally too long, or under the
Hmm.
Constitution we have a cruel and unusual punishments clause, and that's supposed to make sure that punishments aren't excessive. And the case where the court sets out the test for that is a drug case. So it's a guy, he has it's from Michigan. He runs a stoplight, police pull him over, and he has like 672 grams of cocaine in his trunk. And he's a first time offender. He's never been arrested before, but he gets a life sentence. So, it's a lot of drugs, but it's also a life sentence. And so he does
Hmm.
challenge it and say, hey, look, this is cruel and unusual. Nobody gets a life sentence for this. And the Supreme Court rejects his claim, basically saying, if Michigan decides that they want to give you a long sentence, who are we as a court essentially to rethink that, as long as Michigan thinks it's serving one of the traditional purposes of punishment, which could just be incapacitation. So basically, the court's test lets really any sentence pass muster.
Hmm.
And after the court decides that case, we get cases that, a guy gets 50 years for stealing 9 videotapes from 2 different Kmarts. And the court says, yeah, well, that's okay too. Remember, California, that was out of California. They could just decide that's what's necessary. Or another guy got 25 years for stealing 3 golf clubs. Same thing. So I think, yes, drugs are part of it, and drug sentences are excessive in so many instances. But it's also a variety of other kinds of crimes. And the problem is that the court just ignores the fact that the Constitution says it is the role of judges to make sure that punishments aren't excessive. And the Supreme Court just really didn't want to have judges get in the business of overseeing that.
Before we let you run, I know you're on a time schedule here. Anything that maybe you wanted to cover about your book that I did not have the foresight to ask you?
Well, you covered a great range of topics. I guess the one thing I would just say is, my hope is that people on the left are as thoughtful about constitutional strategies and litigation before the Supreme Court as people on the right have been. Because, when
Hmm.
the right decided they wanted to get Roe overturned, it did take them 50 years. It was a long-term project and agenda of just educating people about what they saw as the
Out
the
there
right
every January marching on the.
yeah, and I would just like to see liberals do something similar. Like we could be more on offense rather than defense all the time when it comes to originalism. And similarly, if the court is going to overrule cases, same thing. We should be identifying cases that need to be overruled, because I think for too long at this point, liberals have been content to say, don't like originalism or don't like stare decisis. We don't like how the court is deciding things.
Hmm.
And I just think those battles are you can't win those. Like they're lost. It's a 6-3 court on that. And so
Yeah.
the next stage, I think, needs to be, okay, if that is the methodology, if that's what they're doing, what are some things we could get from this court that would be positive? And I hope this book is at least a starter kit for people of some cases to have reconsidered.
All right, before we let you run, we do need to thank Robin Winston again for being a sponsor of the podcast and the newsletter, along with former Congresswoman Jill Long Thompson. She is Rachel Barkow. She is the author of Justice Abandoned: How the Supreme Court Ignored the Constitution and Enabled Mass Incarceration. I'm Gary Snyder. Don't forget to hit the button down here somewhere to subscribe. Rachel, thank you very much.
Oh, thank you. I appreciate it.
Have a great evening.
You too.
Bye.